Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. Now, today I'm looking at a book which has come to us from the Jordan's Publishing Limited in conjunction with APIL, the Association of Personal Injury Lawyers. Now, the book that we're looking at is now in a second edition, and it's the APIL Guide series that I'm actually reviewing, and this is the Guide to Personal Injury Claims Procedure. Again, I think this is a very helpful book for people who are involved both as younger barristers and solicitors, people who are in pupillage, certainly people who are doing the professional exams who may need a little bit of help, because what you've got here in one small volume is a lot of information which will assist you through the myriad of problems concerning procedure in this area. And frankly, I've found it quite difficult over the years. I did quite a lot of this work in my early practicing days, and so I've always been very pleased at the range of APIL publications available, which Jordan's have taken under their wing. And this book is very much part of the overall list that we have. And this book by John McQuater is particularly important. I hope I pronounced his name correctly. I think it's McQuater. Now, the book is available also as an e-book. My wife Elizabeth and I looked at the book and we had a discussion about it, and we gave the title of our appreciation this. We called it The Best Short Guide from APIL on PI Procedures. We've only written a very short review. This is a slightly longer video clip. There's the book, there's the front of it. You can see the claim form clearly shown there, making a claim. There's the side of the book, and then at the back you've got quite a lot of information about the contents and changes. I'll go through a little bit of what's in the current edition in a minute. The book's quite a big one, bigger than some of the APIL books. You've got paragraph referencing for the index at the back, and then what you have got, of course, at the back are quite a large number of different pieces of information. Let me just take you to that straight away, and what we'll do is I'm just getting to the main bit to give you some idea of what's actually in the book itself. What we've got here, I'm just coming to the last chapter, which is chapter 12, concluding the claim, because it's running the thing through. It's a claims procedure book, so we're starting on it. Obviously logically runs all the way through. You can see how it's structured. You've got a paragraph numbering on the right hand side, and you have in addition to that a certain amount of footnoting which is there, which is purely and simply to give you the much more detailed information if you need to go to a specific law report or anything like that. What we have at the front is the main first page there. Then you've got a forward to the first edition, which was an earlier edition a little while ago. And of course you've got the basic information there, and as I say, it is an e-book as well, which is helpful. Then you've got the preface to the second edition from John McQuater, Doncaster, March 2015, and it just sets out what he was trying to do. He explains what he tried to do with the first edition, and said that since the first edition a lot has taken place. It's been quite a challenge, he says, to get through it. He does make a comment which I think is worth quoting. Personal injury and clinical negligence cases continue to make significant law and procedure for civil litigation generally, confirming that despite all the changes there have been, this remains an important aspect of the legal system for many people. He's absolutely right. It's something that crops up as an issue in the newspapers from time to time, and it's something that we have to bear in mind, because I have to say that some of the procedural aspects of this are quite complicated, and I think this book makes it about as simple as it can be. Can I just say a little plug for APIL, the Association of Personal Injury Lawyers? I'm not a member myself, but I'm very grateful to them for the huge amount of work that they put forward for us. They give a lot of information about the organisation there. Then let's have a look at the contents. There's the contents, quite detailed contents. Protocols to start off with. You can see I'm going to rush through these because there's a lot of information there. You see here that the actual contents, I'm just going through to settlement towards the end, and finally after settlement part 36 is concluding the claim right at the end there. And then you go to the table of cases. The actual contents are very detailed, which means you should be able to find things pretty easily. There's a lot of case law. Not so much, you'll be pleased to hear, on the statutory side. Just that little bit there. The usual suspects are there, by the way. Then you've got statutory instruments, of course. And after that, you've got the protocols. Now, I think the protocols are very important from the point of view of getting to get some idea of what to do. The pre-action protocol for disease and illness and so forth, low value, and a whole range. And this is an area which to many people is a bit of a new area. They don't really understand it, so it's worth reading chapter 1 on protocols. It sets out, it says, any legal practitioner instructed by a client seeking damages for PI must be aware of the law relating to liability and quantum. Obviously we separate the two, as you well know, when we come to a trial. It's also crucial that the lawyer is able to navigate the procedural maze from initial instructions to conclusion, and that's really where we start. We start with the pre-action protocols, and then we run through issue and service, everything you obviously logically see, defence, allocation, case management, disclosure, factual evidence, expert evidence, nice bit on the old hot tubbing, then applications, all that stuff, pre-trial checklist, trial itself, settlement, and finally concluding the claim. So you see how the structure of the book is. I think it's an excellent book in its own way. If you're involved in this book, you should know your way, in this area of law, you should know your way around the book quite quickly. And I'm sure you will find it of great benefit. I certainly have, because from time to time I get cases like this coming at Chambers, and it's quite useful to know what the current state of play is on the protocols without having to go to the main practice books themselves. That's really what the beauty of these books are for us. Let me just say this. It's an established work, I think, now, and it provides practical and straightforward guidance for all lawyers conducting PI cases, serving equally as an introductory text for newly qualified practitioners, which I mentioned earlier, and as an aid-memoir for the more experienced practitioner. It guides the reader through each step of a standard PI claim, providing details of the applicable procedure and focusing on common problems with consideration to the relevant cases. Now obviously it's been updated. I'm recording this in the middle of 2015, and obviously the law is as stated at round about probably about March 2015, but obviously you have to keep your eyes and ears open to any changes. Let me just explain that what's in the new edition covers the following: the new RTA claims process, which I think is not understood, frankly, by a lot of people. It took me a bit of understanding to know how we go about matters. Developments on Part 36. Again, some problems in this area. It has now become complex and there are numerous cases. And I think it is important, again, to bear in mind what you can and can't do on the Part 36, because you are getting a few people playing the system a little bit, if I may say so, and I think it's quite useful to know what you're after there. You've then got the latest cases on disclosure. Nothing much about e-disclosure, but that's coming in at the moment as well. This is again the concept of proportionality. I wish they use the word reasonable as well, because that's what it is in my view. But when they use proportionality, we know basically where they're coming from. That's in connection with privacy, documents, and the latest video and surveillance evidence that you can have. Then you've got things like an in-depth look at expert evidence with a review of cases considering when in personal injury litigation this is reasonably required. And then there are other numerous procedural points, including the developments on setting judgments aside, service, and the changes to the CPR. Now that's basically what the author has come up with, and I think John has been very successful. Let's have another quick look. It's a paperback. It's quite a heavy book for what it is. John McQuater is partner and head of litigation at Atherton Godfrey Solicitors, and he's a former president of APIL. So he's a very experienced man, and I think we're very lucky to have APIL and Jordan's taking this book under their wing. I mean, looking again at the huge amount of information on protocols, just opened it, page 68, part 36 CPR immediately on protocols. So you see it is giving you a lot of information very quickly. One I always like, which happens a lot, failure to file a defence. And you know what they do? They try to get it in under the wire. Then, for those who are experts, expert evidence, a very useful area and an important developing area. I think there's quite a lot on expert evidence, which is unsurprising, bearing in mind when you're looking at PI generally, you are going to rely on the experts. I've just concluded one particular case where eventually I am very much a supporter of hot tubbing, because when you are not getting an agreement between the experts, rather than going through all of the problems of examination, cross-examination, so forth, I think it is actually much more sensible to put them in the box and get the judge to ask the questions. Can I just say, just in case you're worried about that there is no stopping the advocate from asking his or her own questions on behalf of the client as well. But I do think it does shorten things, especially when you've got a clear collision between experts on what's going to happen. Anyway, having said that, I do recommend this book as a very important book for anybody in 2015 who needs to be up to speed in this area of the CPR and the protocols and where we're going at the moment. So thank you very much to everybody concerned for an excellent contribution to this area of law. Bye-bye.